Hello, today is Monday, August 2nd, 2021. I'm Joe Schmidt from TC2, and this is Staying Connected. This is part 2 of our 2-part podcast series where we're covering how state activities to adopt Consumer Data Protection Acts, similar to the EU's GDPR and California's CCPA, will impact your ICT deals. I'm again joined by 2 of my LB3 partner colleagues, Deb Boehling and Laura McDonald. And when we left off, Deb was describing the general controller requirements of these acts, and Laura was about to describe the contracting obligations enterprises may have. Okay, guys, welcome back to the podcast. So, Laura, what are the contracting requirements?
Okay, hold on to your hat, because as I indicated on the last podcast, it's pretty detailed. And before folks start off thinking, hey, this is somebody else's responsibility, my organization, I buy the services. Somebody else is supposed to be responsible for complying with the privacy laws. Hold on, not so fast. First of all, you need to work with those teams. But second, if any of your vendors process information that you share, you must enter into contracts with the processors that does a number of things. First, you have to set forth instructions for processing the personal data, as well as the nature and the purpose of the processing, the type of data that's to be processed, the duration of the processing, and the rights and obligations of both parties. You need to set that out clear. Second, you need to require that the processor ensure that each person processing the personal data is subject to the duty of confidentiality. And of course, you want a general duty of confidentiality overall. And third, you need to require that the processor delete or return all personal data to the controller when the processor stops providing services, except where the processor is required by law, of course, to retain it. You have to be thinking about what are your obligations and what obligations you have to impose on the processor so that you can fulfill those.
So that's a lot of stuff that a processor has to do.
Yes, but there's more. There's always more. You have to require that the processor make available to the controller, you, upon request, all information that's in its possession necessary to demonstrate the processor's compliance with the act. You have to get them to cooperate with reasonable assessments. Deb talked about the assessment obligation on our last podcast. Here, the processor may instead obtain its own third-party assessment using industry standards and controls, such as a SOC report, and provide that third-party report to the controller. But that should be part of your contractual obligations. Subcontractors. If there's subcontractors involved, you need to be sure that the processor requires that any subs that they use pursuant to a written contract meet these obligations. And if you share de-identified data with your IT vendor, you must require it to comply with the act regarding such data.
Wow, that's a lot. In my career, I've read and I've worked with a lot of enterprise contracts, and I'm quite certain that I've not seen most of those requirements.
Joe, it's unlikely any current IT contract includes these obligations, so they will likely need to be amended to comply with these acts.
Really?
Yeah, that's right. And if the idea sounds daunting, we understand, but we encourage you to take action.
Why is that?
The risk of substantial penalties remains. Unlike the California Act, the Virginia and Colorado Acts don't give private parties the right to sue for noncompliance. Instead, enforcement powers are given only to each state's attorney general, and various notice and enforcement procedures are specified in each act. Penalties are specified in Virginia of up to $7,500 per violation, and in Colorado of up to $2,000 per violation, with both states also allowing an injunction against further violations.
Seriously, I mean, what should enterprises be doing to make sure that they're covered?
They need to develop a contract addendum that addresses the specific requirements of the CCPA, the Virginia Consumer Data Protection Act, the Colorado Privacy Act, but is broad enough to encompass similar requirements that may be imposed by other comprehensive state privacy acts on the horizon.
And to follow up on Deb's point, it goes without saying that you can't ignore this stuff. We're just scratching the surface. It's a changing environment, and you need to be sure that you're dotting all your I's and crossing all your T's. And as Deb pointed out, there are a number of states that are looking at this, so you need to look at this comprehensively. Deb and I are staying on top of these acts and other developments, and we're happy to share what we know or assist with any contractual issues or answer any questions, because we understand it's a lot to digest all at once.
Yes, that's right. And stay tuned. Each act is subject to further legislative tweaking, and each Attorney General is required to issue enabling regulations that will provide further detail on how to implement these requirements.
Okay, thank you, Deb, and thank you as well, Laura. This has truly been very informative. Now, as you just heard, you better get up to speed on these state-specific data protection acts, and as Deb and Laura said, they are ready to help. So feel free to periodically check out LB3's website for more detailed information on these acts, and as they've said, it's always being updated. If you do want to talk about other ICT needs, feel free to contact any of us or our colleagues at LB3 and TC2 by giving us a call or dropping us an email. And you can also stay up to date by subscribing to Staying Connected, checking out our websites, and by following us on LinkedIn.